These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
The secured party creditor is the party that holds a paramount security interest in the collateral of a trust, specifically the public trust that we talk about. See, I use different wordings than some others who are out there teaching this type of material. I stay away from the straw man. Using not that I stay away from. I don't use that verbiage because I'm attempting to show you how to be colorable in your use of language. You walk into a court talking about a straw man that's not really that colorable, and they're going to look at you like you're insane.
What do you mean by colorable?
Colorable in that. Well, actually, I think Jack could be the better one to describe colorable. What do I mean by colorable?
Give me a layman explanation of colorable.
Yeah, from a technical point of view, remember when you went back to physics and you're looking at light, if all spectrums of the frequency of color are there, you've got a white light. If all spectrums of color are gone, you've got black, dark. So if it's colorable, it's not black, but it's not white. Something is missing. And the definition of colorable means, like in court, in Scripture it says, how do we learn truth? We learn truth by a little here and a little there. It's through stammering lips, so it's not being distinctly told to you. And it's through the mouth of a foreigner, so it's a language that's foreign to you. Doesn't that describe legalese? Because in terms of legalese, it's foreign to us. They've got their own dictionary. And the same word commonly used is not the same word definition in the legal dictionary. So it's foreign mouth, stammering. The judge is not going to really know everything he says. It's not. And then also it's just a little here and a little there. Well, remember, if you're the witness, you're supposed to take that oath. You promise to tell the truth, the whole truth, and nothing but the truth. That would be black and white. It's either there or not there, and you're getting the whole story. If it's colorable, I'm going to tell you the truth, but not the whole truth.
Colorable is also defined by blacks as a simulacrum or prima facie, just first appearance.
So we're just giving you part of the story. Well, you can't judge anything if you only get part of the story. You're a parent and your child comes home and he got home at 3 a.m. and he was supposed to be home at 11. And so what kind of a story are you going to get out of your child? You're going to say, where were you last night? Oh, I was with Freddie and Joe. And you're only getting a start. Now, the reason they're not going to tell you the whole story is because it's going to incriminate me. Okay? Well, in court, they want colorable conversation. We don't want the whole truth. Don't you dare bring us the whole truth. Movie A Few Good Men. You're in public. You can't handle the whole truth. Remember, a democracy is a military. In a military, you got two problems right away. First problem, military comes in, all the money's gone. It's replaced by military scripts so we can track it. What's the second thing? The big casualty in a military takeover. All truth is gone. The military is not going to tell you what they're doing. They're going to deceive you. It's part of military process. Because if the enemy knows our plans, the enemy is going to prepare to resist our plans. Court is a battleground. It's adversary proceeding. And in that arena, the judge represents the military, which is concealing the whole truth. So in those proceedings in Admiralty Maritime Equity, in our dual trust, the area below the line, that's a different court than what Dorothy's used to in Kansas. In a common law court, we want the truth, the whole truth, nothing but the truth. We want the substance. And if we get the substance and we know the good guy and the bad guy, we're going to give a judgment and they're gone. In a military court, we don't want to hear the truth. We don't care about the truth. We're going to cover up our wrongs, and we're going to bring issues against you by charging you to see how you're going to respond, because it's an inquisition. The only reason we're here in this military court is to determine whether you're the good guy or the bad guy. You're the good guy if you're on our side. You're the bad guy if you're working against us. Other than that, we don't care about your issues. We're the military. We're just here to control and protect.
Are the facts on the moon, you're saying?
Facts are on the moon. We don't care about the facts.
Wait a minute.
Under colorable, we don't care about your testimony.
Yep. So
clarify, we always hear the facts are on the moon. What do you mean they don't care about the facts?
Don't care about the facts. Look at your court setting. In the common law, go back to the Western movies when they convened a court of common law jurisdiction. It was usually in a bar room, okay? And the judge, where was he sitting? At a table on the floor, wasn't he? And where was the jury? They were on some bar stools over here sitting on the floor. And we had the prosecution and we had the defendant. They were all on the floor, all together. What is our courtroom today? We've got boxes separating everything.
And they're at different levels.
We
Court
have the
sits
box
up here, clerk here, testimony comes from here, the jury here. The only people on level ground are prosecutor, defense, and the bailiff. Mm-hmm. Bailiff is a courier, carrying documents from one jurisdiction to the other, from one party to the other. He's acting as your postal service.
Wait a minute. Are you saying that there's different jurisdictions with that in the court? Are you saying, is that what you're trying to say?
Yes.
You said courier, so
Yeah,
you're saying there's on the ground jurisdiction in the sky.
For instance, if I appear outside the bar, I'm off the vessel. The bailiff will come to the edge of the vessel to receive anything that I put into the vessel. He's going to carry it to the captain of the vessel.
So you're going to say that the courtroom behind the bar is really the ship or the vessel?
Everything is by boxes. And remember, communication, what's in a box is in a box, and what's outside the box is not in the box and not part of it. And so you got the building, which is a huge box, but each judge's courtroom is a box within the building. So what's going on in that judge's courtroom is within that box and has nothing to do with the rest of the building. Now, within the judge's courtroom, it's divided into the area outside the bar and inside the bar. So the bar bars off part of the box, making it two boxes.
Slow
There's
down.
the public box and the private box.
What is the bar?
It's a wall that's there separating the public side of this judge's courtroom from the private side of this
It's
judge's
actually
courtroom.
that wood bar then that runs across with the bat doors.
It's a box.
Now, what about some of these courtrooms that don't even have one?
Well, then you're all in the private area, and when you walk through the door, you came into the private area of the court. Because we know these courts are contracts are private, so even though it's supposedly a public court, when you're in front of the judge, you're privately in contract in front of him.
I'm speaking of primarily tickets. You go in and there isn't a bar and things when you're going in to plead guilty, not guilty with tickets. So some of us kind of don't understand that. Is that a private court you're saying?
Yeah, usually when it comes to traffic these days, there is somebody receiving the guests, and you got to sign into a book.
Now that's true, yeah. They want to know who you are, what you're there for.
So you're a guest, so now you've signed in, you have done a quote appearance, so you're already privately there by contract by signing in.
So hold up a second. There you go. Deepak, remember Deepak one time, this is one of our assistants, he was going into court, and the bailiff asked him if he was Deepak Ramapriyan. And he said, I'm here today as Deepak Ramapriyan.
And they wouldn't sign him in the book, would they?
And this went back and forth, and pretty soon the bailiff is saying, well, when were you born? And he says, Deepak was born 1980. He says, where were you born? And Deepak said, Deepak was born in Maryland, Baltimore, Maryland. And so he didn't answer any questions. Then did he technically not sign in when he continued? And this went on for like 8 minutes till the bailiff finally gave up.
Okay.
And now look at what, it's interesting because I actually commended Deepak when he had told me what he had done because he was making a distinction. He wasn't there as the public trust.
Two entities.
So when they were asking him, when's your birthday? He's like, well, I'm not a party to this matter, so you must be really wanting Deepak's birthday. Well, Deepak's birthday is this. Well, where were you born? Well, I'm not a party, so you must be talking about Deepak. Deepak was born in Baltimore, Maryland. You see, he was making the distinction, rebutting the presumption that he's the trust.
This is the same thing when I left one of the prisons there in San Diego, trying to get out the door. The 2 or 3 guys that were there, the guards in a double check, they want your name and the inmate number. And they gave their names, and when they came and they looked at me, I said, the inmate's name is Gordon Hall, and his number is X. They just smiled, and I went on to the next. Again, making that distinction.
Okay, see, when you make those distinctions, you're rebutting the presumption of identification, of being the same as the defendant.
Remember, identification means to make the same. So if you give them any information other than you're going to make yourself the same, and you've identified yourself. So again, back to these deals,
court.
Jack.
Once you're in the bar, there's boxes in the bar. Isn't there the jury box? And what is in the box, what is included excludes others. So there's nothing other than the jury in the box. But since the jury box is a box, it's outside the court. Isn't there a witness box? So the witness sits in the witness box, but that's outside the court.
You talking about when the witness takes a witness stand in that box?
Yeah.
Okay.
Okay. So what goes on in that box does not leave that box. What goes in Las Vegas stays in Las Vegas.
Hold on. So I'm the
So the witness goes into the witness box, and the witness and his words stay in that box. They have no relevance to the defendant and the prosecutor who are in a different box.
Hold on, I'm a little bit lost. So we've got a guy in the witness box. He's making statements. We've got a prosecutor outside the box asking it. We've got a clerk over in this box the stenographer's down below and not even in a box, just at a desk. So...
Yes, stenographer's actually in the court. Who is the court? The court are the parties. Who are the parties? The defendant and the prosecution. That's court.
And remember, they're the two who are on level ground.
So hold up.
And the stenographer's on level ground with them as well. Why? Because what is court? Relationship, the legal relationship between the parties. What's the stenographer doing? Memorializing the contract between the parties.
So hold on.
Hold on. I want to insert this in here. When you're doing a private process, what's the notary's relationship to you and the party that you're doing your process with? A witness, right? Well, guess what? The notary is your court. See, memorializing the relationship. See, when a plaintiff files something in a court and you receive it as a complaint, what's the court acting as? The witness. Mm-hmm. They're just witnessing the relationship. The court has nothing to do with your relationship with the other party. They're just witnessing.
Or another word is they're a facilitator to help the two parties reach an agreement by contract.
Is this where we've heard where the judge says, I'm merely a facilitator or a witness or a referee? We've heard all three of those, have we not?
See, the judge has one of two potential duties. He's judicial or he's an ministerial officer. He's judicial if the two parties are so obstinate they won't agree to a contract. And then the judge has to act judicial and step in based on the contempt or one of both parties to order a decision when they refuse to settle their own case by contractual agreement. But if the two parties are negotiating in good faith, the judge is just sitting here going, I'm a facilitator, I'll see where they're going to go. And if the communication breaks down, the judge will go, well, you made this. Is that offer still good? And it'll open the conversation again.
Wait a minute. I get something back from what I think is the judge in a situation. It's really coming from the plaintiff's attorney or the
judge is just monitoring the contract negotiation. And if they're doing pretty good, the judge will say, I'll tell you what, why don't you guys just go out in the hall, or why don't we adjourn this, and we'll come back in 30 days, and we'll have a status conference and see where you guys are going.
But they don't say that. They just said a status conference.
Yeah.
And it's implied that I need to understand this is a window for me to maybe do something on the private side and submit it.
That's right, because it's been your duty to settle your problem all along. It's not the judge's duty to settle your problem. He only gets involved because you people are not settling your own problem.
Wait a minute. If I've got a private administrative process I did before I received this summons or invitation, isn't it already settled? Why do I got to come in and do it again?
What happens is you go out and settle your problem, and then you bring your settlement agreement
I've got this mortgage
before the judge. And the judge will say, is that what you agreed to? Okay. Is that what you agreed to? Okay. Then it's the official order, judgment, and decree of this court that what you guys agreed to is the judgment, order, and decree of this court. All he's doing in a public forum is agreeing that their private agreement is the judgment order of this court.
Wait.
Go back to Genesis 23, and it shows you how you bring your private settlements into the public for ratification.
Wait, I get my summons, and I conditionally accept that summons on proof of claim that the private record attached here to isn't the agreement between the parties, right?
Now, is there any argument left?
Hold on. We're going to go into that. And maybe we should do that the next session, talk about private commerce and public commerce in the court, because that's something that, if you understand that, you can get your remedy in the court.
Because we all know how to get an agreement on the private side. We're getting pretty good at that, right?
Right. If you guys have been following any of this kind of stuff for a while, you should be familiar with administrative process. So
let me introduce one more issue which is relevant here. Understand this. Under the law, you've got two categories. You've got substance and form. And it's very important to understand the difference. Remember, Scripture says the law is the same yesterday, today, and tomorrow. The law will never change. They're dealing with that portion of law which is called substance. That's where somebody actually is damaged. You know, and damage is the result of some action that really creates an actual damage. If I come up and I say to Gordon, "You're really a son of a gun, ugly so-and-so," he may be insulted, but remember, sticks and stones break bones. That's a damage. Names will never hurt me. And you got to remember in the court, remember with the role playing we were showing you yesterday, that prosecutor and that judge are going to throw names and allegations at you like you're an idiot, you're incompetent, you're a psych, that you don't know what you're doing. That's not a damage. They're doing that colorably to conceal the real truth from the fiction and illusion that's got to go on in the military so that the military doesn't get the real truth out there, which is going to hamper the military in doing their job. So that's not a damage. You know, so many patriots say, "Well, you know, I don't like the way the government did this. That damaged me." And I'm going, grow up. That's military versus you. That's not actual substantive damage. They're calling you some names. The fact that the cop says, "Oh, you can't drive without a license," is not a damage. He is throwing out something for you to rebut, or you've agreed to the contract. Negotiations do not constitute damages. Substance constitutes damage, and the substantive law can never change. Well, what happened in 1933? I mean, they dropped common law courts and they gave us admiralty maritime equity. They changed the law. They changed that portion of the law dealing with remedy, not substance. Remedy or remedial law is the process that you've got in order to obtain recompense for actual damages in the event that somebody violates the substantive law. It gives a remedy on both sides. Remedy is not substantive law. Remedy just provides you a process so that you can obtain some compensation for actual damage which may be lost. The substantive law can never change. The remedial law is only procedural. It can change any time they want it to change within certain limits. As long as a remedy is provided and the remedy gives due process of law and equal protection to both parties, they can change the procedure any time. And so you've got to understand, are the laws, ordinances, statutes, are they remedial and can change, or are they substantive and cannot change? So they've never changed the substance of the law. All they changed is the procedures by which you can get a remedy. So they went from procedures in a common law court to procedures in an admiralty maritime equity court. As long as you have a remedy in this new court proceeding, it does not violate anyone's rights. So all these patriots are going, "I want the common law." You can argue about that until you're blue in the face. But the problem is, it does give you a remedy. You got to understand what the procedures are to get those remedies. But as long as it does provide you a remedy where they do not discriminate against you, it's okay. Remember last night in the role playing when Smith was out there playing Dwight and he needed to have his hearing. He has a substantive right to be able to be heard and bring his remedy. What were the prosecutor and the judge doing? They held their little hearing to begin with under color of law, and then the judge said, "Dwight, do you understand me?" And then the judge shut up and goes, "Well, Dwight, if you're smart, this is your hearing. They're giving you due process and equal protection. We know we were here today to hear what you brought to the court. We're going to give you that opportunity." Okay, Dwight, you idiot, you did not bring your hearing in front of us. You answered us, so you're out of here as a debtor. You just forfeit your hearing. But did that process of admiralty equity maritime, did it give him an opportunity to speak? Yes, if he took it. He chose not to because they kind of led him along a path and he didn't know what to do. But they did not violate his rights. So understand there's a difference between the substance of what you're trying to get done and the procedural rules or remedies that you are constrained to use to get the remedy for the substantive violation. So what we're talking about here this weekend is not common law procedures, because the remedy changed in 1933 because we went to admiralty maritime money instead of lawful gold and silver. When you change your money, you change your law form. You go from a remedy on land to a remedy in the style on the vessel on sea, because choses and actions, Federal Reserve notes, promises to pay are money of the sea, not money of the land. So we're going to talk about procedures in these courts based upon the law form, because we're dealing with money on the sea if we're dealing with the public money below the line on our map. Now, what Brandon was talking about this morning, for everybody that knows 1099 OIDs, because there were no ands, is that he's talking about how do you exchange rights for people with money that's dealing with the DTC, which is good as gold, because yesterday we said if you use your asset funds, don't you have both legal title and equitable title in those funds? And if you have legal and equitable title in those funds coming electronically out of the DTC and the private side of the FRB, isn't that what you had when you had a gold coin in your hand? You had both legal title to the money and you had equitable possession of the money. So if you get up into the DTC and understand that asset account we were talking about yesterday, that's good as gold. It's better than gold, because colorably, can you distinguish an electronic exchange between banks coming from asset fund or coming from liability funds? No. And isn't the banking system future everything electronic? In England, haven't they told you that after the year 2018, there will be no paper money, no checks, nothing. Everything's going to be electronic. So are you going to be able to tell who's operating out of asset accounts and who's operating out of liability accounts? No. You're going to be hidden in plain sight. Everybody's going to look the same, but the law governing the transactions is going to be one thing for the people operating out of asset accounts. They have unalienable property rights and legal title. And something else for the slaves operating out of the liability accounts. They have no rights. They have some privileges and they have some benefits. So understand the context in which we're bringing you, and the administrative process is procedural remedies. And we're going to choose to start our remedies outside the public in the private and bring our concluded process into the public. But if you do a general appearance to the summons and complaint in the public, and you're under the rules of discovery and you're operating through attorneys, you're doing kind of a quasi-public-private process. It's not in front of the judge, but it's under the scope of the public case, because you've done a general appearance to the public issues, and you cannot bring in a private set-off as though you were a creditor, because everybody in public is a debtor. The only question is, are you a better approved debtor or a lesser approved debtor in the eyes of the judge?
So,
Better take a break, Brandon.
So, as we began in the colorable conversation, I mentioned that there's certain terms that in this arena you've become familiar with. like the straw man. But you're not going to walk into court talking about a straw man. So let's start to shift our understanding and make some distinctions so that we better understand our relationship with these various trusts and entities that we do deal with. Whenever you hear me refer to the public trust or my public trust, that's the straw man. Now, I don't refer to a living man either, because in their world, that's another very uncolorable phrase. Remember, yesterday I explained to you that under trust law, a private trust, that's a non-statutory trust formed outside the jurisdiction of the United States, is a natural person in the public. So whenever I say the private trust, I'm talking about what many refer to as the living man. So the relationship between the private trust and the public trust is that the private trust is the trustee of the public trust. Let me say that again. The private trust...
That's you?
Well, is it me? No. I am.
We're a little confused
and I have
here.
no title. See, you may associate yourself as a living man or woman, but I don't like using that phraseology because many people then associate themselves with the body.
So when you say you...
The body is a vessel.
So when you say you, you're really talking you, the spirit inside here that animates
I'm
the
saying,
process.
when I say I'm talking beyond the spirit, because I have a spirit, I have a soul, I have a mind, I have a body. But I am none of those things.
So Brandon is saying that when it's the spirit, the living man, but we don't refer to it that way, you're box one.
And I refer to it as a private trust, because anything you give a name to, there is a trust relationship there.
So the private trust is box two, and it's up in the Republic, outside the jurisdiction of the United States, which is below that line in the public.
So box one has no name.
When Moses said to God, "You're sending me to Egypt, and you're sending me as an ambassador to contract. Who is it I shall say has sent me?"
This is at the burning bush?
Yes.
You got it. Now the issue is, if God gives a name, just like the judge said, "What is your name?" Why does the judge want your name? Is he going to send you a birthday card? Is he going to come friends with you, invite you over to the next anniversary party? He wants a name because the name attaches to a trust, which becomes responsible and liable for a debt. Now you've got God at the burning bush, and Moses is saying, "Who are we going to pin this on? Because I ain't taking responsibility in Egypt." And God goes, "You ain't going to pin it on me. I'm a creditor. Just say, 'I am that I am has sent you.'" When the judge said, "Who are you?" "I am." "You am what?" "I am." That doesn't really answer his question. He wants to know how the account is going to get billed. So when you're there saying, "I am the authorized representative for the private trust," which is responsible for the public trust. Public trust is box 6B. Private box is box 2, and I am is box 1. But that's way too much information for the court in those terms, because that is the whole truth and nothing but the truth. We are in the military. We don't want to hear the truth.
So you go in and you say, "I'm here today as the authorized representative
Very
for
colorful.
the surety
Well, you know,
over the defendant."
But you see, I defined that to be the defendant. Who the hell were they looking for?
The defendant.
The defendant. I just redefined defendant to be all of those really good things. Now, if I don't want to argue with the court, does the court want to argue with me? No, because whoever argues is a debtor. So I just define defendant, which is who they're looking for. And now they're going to tell me, but you can't be that defendant. Oh, you want me to be the other Alice? Is that who you want me to be? Now we're on a discussion in which the people in the crowd are going, Alice and other Alice? What the hell's going on here? And the court is exposing too much by trying to object to who I agreed to be. But when I agreed to be the authorized representative for the private trust, who's going to set off this debt? Either the private trust or the public trust. Either Box 2 or Box 6B is going to pay this account that's in that court. The court wants Box who to pay the debt?
Box 2.
6B. You're offering payment by Box 2. Box 2 is foreign currency to them. No, we'd rather you bring local currency, Federal Reserve notes. Well, what's wrong with foreign currency? Are you objecting to foreign currency? Well, we prefer local currency. Then you're telling me that you will accept foreign currency. Well, we want local currency. Well, what they don't say, no, we won't take foreign currency, is more important than we want local currency. So the issue isn't whether the account's going to get settled. The issue is, where is it going to come from, the republic or from the democracy?
So they have a preference, but they're not attached. Didn't we discuss that yesterday? So, and in fact, when Remedy was created in this new public system, one of the protections was that no public entity could demand payment in any form.
This sort of gives credence to that story we heard the one gal asked the judge or the clerk, how shall I pay it? How do you want me to pay it? And the response was, any negotiable instrument.
Right. Or, I don't care if you pay in coffee beans. Right. And people have paid in coffee beans. Because they cannot demand payment in any form. Because they're seeking the protection of the public system. They're debtors. Everything seeking the protection of the public system are debtors, so they cannot demand payment in any form. That includes all corporations, all U.S. citizens. So if somebody wants to try to sue you in a court seeking a public privilege and benefit, they can't go in there and demand that you pay your debt in silver. They can't, because they're seeking the protection, benefits, and privileges of the public system.
So this is why if I put in what we call a money order or a coupon, they have to accept it?
Yes, absolutely.
And that's why they don't send it back. Or if they did send it back, the rule says it's discharged then.
Exactly.
So I get it coming and going, doesn't matter, does it? As long as I tender it and know how to stand on that, right?
Now, in private contract between private party A and private party B, you can create whatever you want and demand payment in whatever form you choose. How many are familiar with Tim Turner's process? Okay, a couple in here. Okay. Have you noticed in his counterclaims, he demands payment in a certain form, doesn't he? Because he also doesn't want to accept benefit and privileges of Federal Reserve notes, so he's like, okay, yeah, this counterclaim is $7 million, and oh, by the way, $1 is 1 ounce, 0.999 fine silver. Why can he make that demand? Because he's not a public entity. He's not seeking the protections, the benefits, or the privileges of the public system, so he can demand payment in whatever form he chooses. So can a court or can a law firm or can a bank demand that, no, you must pay with Federal Reserve notes? No. Can they demand that you must pay in gold? No. Because they're debtors. Everything in the public system, every entity in the public system are debtors. They cannot demand payment in any form. Do you have a microphone? No. He's going to bring you one.
You were just mentioning that you can't. You're just mentioning that you can't demand payment in any certain form.
In public.
In the public. Now, I guess knowing that, is there anything that you have to? Is there any certain way that you have to prove that or validate that, or you could just carry out that in your actions?
Remember, your process is proving that. I sent in a napkin with $1 million written on it through a notary. And then I got a certificate of non-response. What did I just establish? Their acceptance of my $1 million napkin. So yeah, we go through the trouble of doing proper banker's acceptances, of drafting proper negotiable instruments. But in fact, if I have my notary witness that, yeah, I'm sending them 1,000 coffee beans.
But more important, you're saying, is that third-party witness that you did that act and that they did not respond is more important than the form of what I did, but the procedure of what I did.
Right, because what we're doing is the notary is serving as a witness to their acceptance.
Why a notary over just somebody regular?
Because it's a notary's duty to witness. And see, in court, if I ever do choose to bring my record into a court, there's the rules of evidence. And under rules of evidence, they have what's called the hearsay rule. And anything that you've heard people, I put my affidavit in. Nobody rebutted my affidavit. And yet, did they get their remedy? No. Because the affidavit is just hearsay.
In the public.
In the public. An exception to the hearsay rule is that if a third party's authentic record is submitted into evidence, the private side of the court, that record is an exception to the hearsay rule.
Because you really can't testify in your own case is what you're saying. So
right.
anything you
so
say...
you're getting this third party to testify. What you're doing is you're saying, hey, a higher court has already made a judicial decision on this matter.
Why is the notary a higher court? I don't get it.
Because it's from the private. See, a notary sits on the fence. A notary is an agent of the Secretary of State. Secretary of State sits on a fence. I've got a public side, I've got a private side, and all my agents have a private side and a public side.
Are you saying a notary is a direct agent to the Secretary of State?
Absolutely. Where do you think they got their commission?
So it's really like the Secretary of State?
Yeah.
Doing it.
Your notary is like the Secretary of State.
Secretary of State's kind of operate in what capacity out here?
Remember yesterday, there are 3 officials that stand between the public and the private, and they're trustees. They are the Attorney General, the Secretary of State, and Secretary of Treasury.
Oh, okay.
So they stand between the public and private. So if you want to communicate from the republic down into the democracy, you have to send it through channels. One of the channels is Secretary of State.
They're kind of like a bailiff in a court then. You need that intermediary between public and private, somebody that's been assigned that duty or capacity.
Right, and the Secretary of State's agent to do that is basically the certificate of protest out of the notary. If you go back to Congress in the 1850s, the Congress understood that there was going to be a flip in the law form so that the states were going to go from sovereign and republic to basically captured states under the national government, which is the democracy. And before that switch legally took place, Congress passed a bill that established the fact that the notaries would be allowed to bring this process from the people are in the republic, so that it would be recognized by the officials in the democracy, so that the people would have a process of communication whereby their records and evidence had to be accepted by the officials in the democracy. And so that national legislation enabled the state secretary of states to appoint these notaries to be able to convey your record from the republic into the democracy, and it compelled the democracy to recognize that channel of communication.
So most notaries don't even know this. They just think they just notarize signatures, right?
That is correct. In fact, there is a proposed bill. I don't know if it's been passed in California.
I know they're working on it. I don't know
There
if it's
is
been
a
passed
bill
yet either.
out there which would limit the capacity of most notaries generally to do certificate of protest. Now remember, they can change procedures anytime they want, as long as they don't violate substantive rights. Now, substantive rights includes the substantive law plus the right of due process of law and equal protection to have a remedy.
But keep in mind that a protest is defined in the public. I actually stopped using protest a long time ago because I don't need it to be in the form of a protest. I need the substance of them witnessing that there was no response.
Are you saying that you no longer use a certificate of protest?
No, I haven't used a certificate of protest in probably 2 years.
He uses the equivalent in witness.
Exactly. I use certificate of non-response, certificate of non-performance. I use these other forms.
It's not what you call it, it's the substance of what it is.
Exactly. But I think there's an interesting aspect to this law in that they say, unless the notary is working for a financial institution. What's the straw man?
You
A
are
financial
an
institution.
investment bank. You are a financial institution. How many notaries are going to know that? You may have to educate them.
Oh, can we get a microphone?
I'm curious. Is this on?
No.
Closer. There we go. You're talking about a judge that sees both the public and the private. And I'm wondering, since the judge has this knowledge when we come into court anyway, are you encountering intelligent judges?
Absolutely.
Why would I want to be a debtor judge anymore if I'm witnessing in my courtroom what's coming in and creditors are behaving with much more authority and power than I am as the judge?
Judges are getting compensated in numerous ways.
As much as a creditor could possibly operate in commerce?
How much of your $3.5 billion could you realistically spend without getting yourself so public that you're in other problems anyway? It's kind of after you're at a certain level. Think of wealth. You know, somebody that has none comes into it. You're a lottery winner. You know, the first thing they say is, my life ain't going to change. That lasts about 24 hours. And then after that, what are you going to do as a debtor? You're going to buy a new house. Ooh, yippee. You're going to buy a new car. Oh, yippee. You're going to pay off all your debts. Ooh, I'm no longer a debtor. Now, you're going to go on vacation. Okay, yeah, well, you know, 25 months at sea is getting boring now. So what are you going to do? Buy your second house, your fifth house, your 54th house?
So,
you know,
Jack,
life really means after you come into wealth, you're going to have to start changing your whole concept. Of course. Because your average everyday problems you used to have, keeping the lights on, are now not there anymore. But I mean, you're either going to waste away and destroy yourself physically or mentally, or you're going to take on a responsibility in which the money means nothing. The concepts, the ideas, and goals that are going to drive you to be the best that you can be or kill you are going to come into play. So go back and see what happened to lottery winners. So what you're saying to me is, gee, if you could go out and get 3.5B times 10 as a minimum, and the judge knew about this, why aren't all judges retired in luxury? Well, why wouldn't you be the same thing? Because after the first 1 million or 10 million, what are you going to do with your life that's going to give your life meaning and credit to you as an individual, where your children or somebody going to look, Dad was really pretty cool. His money didn't mess with him. It's not about the money, because in reality there isn't any money. It's all play monopoly shit. The only thing we got going here is, who are you in your spirit? Brandon said, I am box one. I am. It's a spirit. It ain't even my body. What are you going to do for that spirit? What is going to be your focus in life? And so a judge is going, I got the chance here. Maybe once in a blue moon, I will see a Gordon come in struggling, and I'm going to see this man who was on probation or going to prison or owing $4.5 million, and I'm going to see this guy turn his life around and bring an exciting It's the first time I've ever had somebody stand in front of me that's getting it right. Yippee, this is a great day.
Yeah, but how do I know,
Made
Jack?
the rest of his life.
How do I know he knows
more
what?
important than the money.
How do I know he knows what's going on? Is there judges school? Do they go to these things? Do they contract law? I mean, how do we know the judges aren't?
How
know this
much
stuff?
time did it take you this weekend, if you had no clue of what was going on, to at least absorb the concepts we gave you? Now, whether your mind truly believes that's out there or not, that's going to be with the heart and the faith. Maybe you're going to have a problem with understanding that you really do have 35B that's accessible to you under certain terms and conditions. I got a 19-year-old niece, and I sat down with her one day. She's listened to me for a lot. And I said, she's 19, going on about 15 yet, or maybe 11. And like most kids that age, you know, they know it all, and they know that they're free and they can do anything they want. They just haven't quite figured out what life's about yet, but they think they know. It's about finding my boyfriend, who I've met 24 hours ago, and he's destined to be my husband, and I'm in love. Okay, so I sat her down one day and I said, what would you say to me if I told you you were a princess from a very wealthy family and you could do anything you want? Well, she used to come and work for me as a secretary and clean up where she's getting her life together, and all of a sudden next week it was, Uncle Jack, I got other things I got to do. I'm not showing up anymore right now. It scared the crap out of her. What did we say yesterday? We are all programmed for failure. We've seen it all the time. Oh, I love Freddie. Oh, he's gone. He spit me off, man. So, oh, I can take that. That's just one more rejection. We are programmed for rejection and failure. We are not programmed for success. So many of you people are going to find it very difficult to understand that God would actually leave 10 talents here for you that he didn't tell you about directly, and you don't know they're there. And oh my God, if I went to get my 10 talents, I'm going to have a lot of problems, and they're going to come after me, and they're going to test me, and they may even lock me up in prison for trying to get at a Treasury direct account, because we don't have the authority to do that. There could be a million excuses why you're not going to go after success. But that's up to you. But how hard is it to just grasp the concept that in 1933 they decided to separate your assets and your liabilities, give you the liabilities, keep the assets in trust for you and not tell you about it and see if you were ever going to do anything about it? Is that a difficult concept? Is that so improbable that that's pure science fiction, and as a judge, I don't believe it for 1 minute? Or is that a concept that, having heard it, go, okay, so what do you want me to do as a judge? I want you to sit there, and we're going to give you a lot of perks because you know what's going on, and don't tell anybody in the public. But your only job is to be the gatekeeper between those people that are responsible enough to be awarded their talents, or to say those people are idiots and it's going to hurt them if they get their talents. So you go out and be a gatekeeper, and we're going to pay you a huge amount of money. That's what it's all about. Yes, ma'am?
If a notary can be both on the public and the private, how
like
would that
everybody.
How does it or can it affect you if you become a notary?
It's another job. If you operate your private commerce up here,
yeah,
you can't go down and be an engineer. You can't be a nurse. You can't serve in some other capacity. You know, there's life and there's my job.
All right.
They're different. My job is helping people, which is part of my goal in life. But my life is not my job. It's just an extension of me. Now, we have somebody that's going through the process of getting membership in DTC. Mm-hmm. Okay, and this party that's going through the process of getting a membership in DTC, they have already reported with their birth certificate, their social security card, yada, 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 okay? And in this process of being inducted as a member and offer and rejection or offer and acceptance, This lady was applying for a job in the public which required a security clearance. And she filled out all the forms. And the party that's doing the security clearance came back to this woman and said, we can't find your fingerprint files. And she goes, well, that's funny. They should be under the Social Security. We checked. They're not there. Could you have had another Social Security number or something else? And she's going, no, run it again. Comes back a week later, same thing. So this lady said to this gentleman, is it possible that the process we're going through with the DTC would affect the ability to locate certain files for a security clearance? And the party goes,
make sure you
is not said more important than what is said? So what's the answer to the question? You bet. But see, in that capacity, doing a security clearance in the public would probably put you in a position which would then prejudice your ability to operate in private going through the DTC.
Now, be clear and make the distinction. There's a notary public. Who becomes a notary public? And when I say who, what am I saying?
He's talking about his public trust.
The public trust, not the private trust.
Gotcha.
Right?
So you still have all your private
You can
remedies.
still operate your public trust as a notary public, right? Are you a notary public?
Right. Just my private corporation is the notary public.
No, your public trust is the notary public.
Okay, got it.
Okay? And that particular, now, your public trust has a capacity to operate on the private side. But it doesn't mean you're the notary public. The public trust is a notary public. You've just increased the capacity of your public trust. You've given it an extra, you've added
a duty to do.
You've added something to it. I could have my stock car that I buy at the dealership, but then when I get it home, I can add fancy windshield wipers, and I can add, some stuff on the inside, and I can put my little navigation unit in it. I'm changing what it is in form.
The public trust added the feature of a driver's license. The public trust added the feature of an airplane pilot's license. The public trust added the feature of a registered nurse. The public trust added the capacity of a doctor practicing certain medicine.
MDs, chiropractors,
surgeons.
All of these little titles and these designations, those all belong to the public trust.
It doesn't mean you get to notarize your own documents or that kind of thing. And for you that don't have notaries in your area, it's not difficult to get the notary status for your public trust. And so consider getting that so you can take care of each other's documents.
The public trust got a certificate of graduation from elementary school. The public trust got a certificate of graduation from engineering college. All of those titles go with the public trust, which is box 6B. None of that goes with box 2 or box 1.
So why then would we give in return our driver's license then, if that public trust is who's been licensed to drive?
Because you may not want to have a public exposure somewhere down the line. You're going to retract totally up into the republic again and have no presence down in the public.
If you choose. It's not to say you can't still operate your public trust with a driver's license and everything else.
It's up to you.
Just make sure you make the distinction.
I've told you.
Gordon Hall has a driver's license.
I don't have one. Gordon has one.
Gordon Hall does.
I don't have a credit card, but Gordon has one.
The other Alice has all of that stuff. Alice does not.
Now, he just so happens, as the executive trustee of the private trust, which is the executive trustee of the public trust, he has the paramount security interest in everything that belongs to Gordon Hall. So
I carry his stuff around for him because I don't trust him. I carry his driver's license around in case he needs to rent a vehicle or something or get on an airplane or something. I've got something for the public to see.
All right, this is a good point. What we'll do is we'll take our break now, and then we'll continue.